In this video, I'm going to be looking at the Paper 2 topic of delegated legislation, in particular, the controls on delegated legislation and how effective these controls are. So, to start off with, we'll look at the controls by Parliament. The first one of these is the approval of the Parent Act. The Enabling Act sets out the limits within which delegated legislation is made. The Act states which minister can make the regulations, the type and region affected, and whether the department must consult others before making the regulation. The next parliamentary control is negative resolution procedure. Most statutory instruments will be subject to this, and it means that the statutory instrument will become law unless specifically rejected by Parliament within 40 days of publication. And then on the other hand, affirmative resolution procedure affects only a small number of statutory instruments. It means that it won't become law unless specifically approved by Parliament. The final parliamentary control is scrutiny by committees. The Joint Committee on Statutory Instruments and the Secondary Legislation Scrutiny Committee are both bodies that check the legislation once it's been made. Now, how effective are these parliamentary controls? Well, a problem with negative resolution procedure is that there are so many statutory instruments made every year that very few are actually looked at. A problem with affirmative resolution procedure is that Parliament cannot amend the statutory instrument and are only able to approve, annul or withdraw. Scrutiny by committees is very effective, however still has the problem of not being able to check every statutory instrument due to the large number being made. Where committees are also less successful is that their review is only technical. They can't alter the regulations or stop them from becoming law, they can only notify Parliament of the issue. Now let's look at control by the courts. So the main method of this is judicial review, and this is a way of challenging a piece of delegated legislation on the ground that it is ultra vires, and that means that it goes beyond the powers granted in the Enabling Act. Cases will be heard in the King's Bench Divisional Court, usually by 2 judges. There are 2 types of ultra vires, the first one of which is procedural, and this means that it is ultra vires because the procedure set out in the Enabling Act has not been followed, and this is seen in the Aylesbury mushrooms case. The second type is substantive ultra vires, and this is when the rule-making body didn't have the power to make the rules in question, and this is seen in the case of Boris Johnson. Now looking at the effectiveness of the controls by courts. For judicial review, the challenge will likely be made against a government department or public body who will have greater resources and funding to defend the legislation. On top of this, the people allowed to make an action in judicial review is also very limited, and they'll not receive any funding for it. Another thing is that an action must be launched within 3 months of the original decision. This is what a question might look like on this topic, and this is actually a question from the 2022 paper. I hope this video was useful. Have a nice day.